This symposium and this annual criminal justice lecture can be easily situated in the context of a number of areas that we would like to develop, areas of specialization that we would like to develop in the context of the new law program at Goldsmiths. The first one is an emphasis on socio-legal studies with a strong focus on criminal law and human rights. These two areas individually, but also looking at the interconnections between the two, the challenges, the opportunities there when you are at the intersection of criminal law and criminal procedure on the one hand, individual rights, procedural rights on the other. It's inevitable to think about the relationship between law on the one hand, technology on the other, and not least in connection with how the use of new technologies, artificial intelligence is a primary illustration here, is going to affect the operation of law in the near future, and how it is going to affect the operation of criminal law and criminal justice more specifically. We had the Council of Europe, for instance, earlier on this month. One of their key experts working on artificial intelligence and human rights, and she was able to raise a number of issues in relation to how we will need to be extremely careful not to deploy the use of artificial intelligence before we have given serious consideration to potential implications about human rights. The third area, and I think again it's inevitable that law schools are going to place emphasis and have already been concentrating in this area for some time, is Europe, Brexit, post-Brexit regulation, how we are going to fill the gaps in terms of existing legislation, in terms of the institutions that need to be in place in relation to a number of areas, trade obviously, but also security, so as far as criminal law and criminal justice is concerned, again, a number of important. Today's symposium, in a way, has a very strong connection with all these issues. Obviously, the social-legal issues and how we need to try to understand how criminal justice operates within its socio-political, cultural, institutional context. We need to reflect on the impact that technology has, the impact that technology can exercise upon the operation of criminal law, and also we need to give serious consideration to the operation of criminal justice, operation of criminal law in the post-Brexit landscape. And the real privilege of having Lord Hughes doing a keynote for us today, and that is partly and importantly connected with these links that we've been able to develop with the Inner Temple and the Bar and Judiciary more generally in the last few years. Really looking forward to exchange of opinion and ideas in the cosmopolitan spirit that is very central to this symposium and very central to the new law program at Goldsmiths. Thank you very much. Thank you.
My name is Nikki Lacy. I'm from the LSE, and I have the great pleasure and privilege to introduce our first and keynote speaker. Before I do so, could I just congratulate Goldsmiths and Dimitrios in particular for setting up this fantastic day, and wish the new law school an enormous amount of good fortune. I had the pleasure and the excitement really to be an early part of the new law school at Birkbeck 20 odd years ago, and I know how exciting it is, but also how much hard work goes into it, and I sort of salute you and wish you well, and I think this is a wonderful initiative. And of course, poignantly and incredibly timely topic. And I know it's going to be a very, very exciting day. He really needs no introduction. You all know that he sort of had the summit of his very distinguished judicial career in the form of 5 years on the Supreme Court, from which he retired last year. He was also Vice President of the Criminal Division of the Court of Appeal, so really there could be nobody better qualified to introduce our conference today. So thank you very much, Lord Hughes, and I'm going to sit over here so I can see.
Thank you very much indeed, Professor Lacy, and if I may say so, you've said everything that I would like to have said about the Goldsmiths venture. Well done, it's terrific. And we are absolutely thrilled at the Inner Temple to have Professor Giannopoulos as one of our academic fellows. The links that he's been talking about between the profession and distinguished academic students such as yourselves is absolutely vital. They do not exist in silos, and they must not. And it's a great honour to be asked to come and contribute a few preliminary, and I promise you pretty elementary and inconsequential thoughts to the topic which I see is slightly differently described on the programme, but which Demetrius described to me in an email as how criminal procedure thinks of international human rights. Well, how do we? 70 years on from the drafting of the European Convention, we can now start, can't we, from a pretty broad level of international agreement as to the terms, the language of many of the fundamental rights that we're used to encountering, the ones that chiefly, there are others, but the ones that chiefly impinge on the criminal justice system are obviously 2, life, 3, cruel and inhuman treatment, 5, detention for cause shown, 6, the various features of the right to a fair trial, and the bar on retrospective offence creation in Article 7. And although the ECHR was one of the earliest formulations of nearly all of these rights, since then they've been expressed, haven't they, in similar terms all over the place. In big international instruments such as the ICCPR, but also in many countries in the constitutional instruments. The Canadian Charter is an easy example, and so are nearly all the Westminster model constitutions which have been adopted in former British but now independent states. In nearly all of those, most of the fundamental rights that we're talking about are there entrenched as constitutional rights. The extent to which they're entrenched here in England and Wales is, of course, a little more nuanced, since the Human Rights Act is simply a statute like any other, at any rate in form. But we needn't get into that largely theoretical issue to answer, or to at least to address, the question that Demetrius sent me. And I think my answer to it is this: how criminal procedure thinks of international human rights. In my last posting over there, we were entirely accustomed to occasionally analysing points of criminal practice in terms of the rights that are set out in the ECHR, and I want to come in just a minute to a few examples. They're all very well known. But a more direct answer to the question is, I think, this. I suspect that if you were to ask mainstream English criminal advocates, the sort of people who are daily tackling trials, either on behalf of the Crown or on behalf of the defendant, if you asked them what they made of this relationship, you'd probably get one or both of two answers. The first would be, yes, we're entirely familiar with these fundamental rights. If necessary, we're used to referring to them in argument. But secondly, it is only very rarely necessary in the average criminal trial. These rights, most criminal advocates, I suspect, would say, are implicit in English criminal procedure. We scarcely need these days to analyse our law in terms of them. English criminal procedure had largely arrived at these rights long before the drafting of the ECHR. The right not to be detained without cause shown to a court was guaranteed by habeas corpus for the best part of 3 centuries before it found its way into Article 5. The law placed the onus on the Crown to prove its case in criminal trial, again, hundreds of years before it got into Article 6, and torture, Article 3, was outlawed in the 16th century. The 17th century, and so on. What I think is interesting, you may or may not agree, What I think is interesting is the discussion which has ensued since the terms of these fundamental rights became reasonably settled after the Second World War. And the discussion which is interesting is the discussion about their extent and their content. The terms have barely altered in the various instruments. There are minor differences. Article 7 is expanded in Article 14 of the ICCPR to include lex mitior, for example. But by and large, the terms are simply the same. What has happened through the devices, or means, or mechanics of fairly energetic judicial glossing. That's only too obviously true of one or two others of the articles, and the one that will immediately spring to mind is the very elastic Article 8, aptly named the indefinite article, which has, of course, whatever else it may be alleged to include, given us a law of privacy, which we didn't have before. But it's also true, the glossing process, of the core criminal articles, which are 5 and 6, and for that matter of 2 and 3 as well, which also impinge, don't they, on our criminal process. And what I would like to suggest is that it's useful for an English criminal lawyer to look at two features, there are of course others, of this process of judicial creativity. The first and obvious one is the extent of it. These fundamental rights have been expanded enormously beyond their core language. But the second, which is interesting, I think, to English criminal lawyers, is the very valuable and interesting interaction which that process has thrown up. Interaction between, on the one side, the common law tradition, which we're used to, and on the other, the what I will call the European civil law or Code Napoleon tradition. That latter tradition does not start from the same place as the common law, and it does not adopt the same judicial techniques to which we are used in the common law when it comes to interpreting the text of legal instruments, such as the ECHR. And I think it behoves us to remember, when we encounter these differences and occasionally are irked by the imprecision of some of the activity, it behoves us to remember that whilst the common law may be very long-standing and we're rightly proud of it, and it may be very widespread across the world and we're rightly proud of that as well, it is by no means a universal system. And it probably isn't quite in the majority, numerically at least, in systems. And it also behoves us to remember, I think, the difference between running a very long-established legal system such as ours, in which an enormous amount can be taken as read, and, on the other hand, running a transnational court such as the Strasbourg Court, where the judges come from an enormous variety of cultures, from a huge range of personal career experience, where there's no single common language, where the range of systems under consideration is enormous. An English case, we sometimes forget, is a great rarity in Strasbourg. They quite like them because they come slightly better packaged than some of the cases that come from, for example, Russia or Turkey, where they come in enormous numbers. But the Strasbourg Court is having to cope with all the systems of former Eastern Europe, as well as former Code Napoleon Central Europe, as well as the common law. And when we run into occasional elements of frustration, we ought to remember just how difficult it is to administer a transnational court of that kind. Given that cautionary note, there are still, as you all know, have I pressed something I shouldn't? Don't worry. With that cautionary note, there are easy examples of direct importation into the UK systems of fundamental rights as interpreted, not simply as written, but as interpreted in Strasbourg. Nice, easy, simple, very well-known example, CADA and Her Majesty's Advocate, 2010. You'll remember that in Saldus against Turkey, the Grand Chamber of the Strasbourg Court had interpreted Article 6.3c as giving an arrested person the right of access to a lawyer before being interrogated. Well, fine, but it's not, of course, what Article 6.3c says. What Article 6.3c says is that a person has a right to defend himself through legal assistance of his choosing and to state assistance if he can't afford to pay for it. There's nothing there about access to a lawyer before interview. But that's the stretch which had been made in Saldus. Although it's not there in the text of the article, cum cada in the House of Lords simply accepted the Strasbourg extension or interpretation of it, and the result was that the practice in Scotland thereafter had to be radically changed. Because hitherto it hadn't been in ignorance of the point. Hitherto in Scotland, a rational decision had been made that it wasn't necessary to render automatically inadmissible the product of an interview between a policeman and a suspect on the sole ground that he hadn't had access to a lawyer. You looked, the Scots would have said, until CADA, at whether there was any unfairness involved. And we're used enough to that in England and Wales when it comes to the way we deal with breaches of the codes of practice under the 1984 Act. But what happened in CADA was simply the Scottish system went into reverse. Interestingly, another interesting thing about it is, of course, that it went into reverse prospectively, but that's another question and would take another hour's lecture. Now that was, on the face of it, interpretation of the terms of the article. In reality, it was judicial legislation in Strasbourg, based on the kind of review of national practice all around the Council of Europe, which they're in the habit of conducting. It's one of the things they do, you may think, extremely well, is to produce a synthesis of practice around the member states. Another way that the convention rights have been expanded is afforded by the slightly different technique of attaching to an article an ancillary or secondary duty to investigate things which might involve a breach. And again, the classic, of course, is Article 2, which was expanded to require an inquiry into deaths in state custody or at state hands. It's not what it says in the article. The article says that you have a right not to have your life put at risk by the state. It doesn't say anything at all about an investigation, but it's a perfectly rational extension on the basis that the primary right won't be effective unless you also have a secondary right to investigation. But it's pure judicial legislation of the kind which, if it happened in relation to an English statute by an English court, would attract, rightly, as some of us would say, a great deal of criticism. But it's a different approach. Now that's what happened there. That particular expansion of Article 2 didn't cause any trouble in England and Wales because we had a long-standing coronial system, which, if you remember, the Normans had invented, although it applied only when the dead body was Norman. But what has now happened, of course, as you know, is that a similar duty of inquiry has been attached to Article 3. And then that has been expanded further again. And this was all before the Supreme Court, quite recently, in a case called DSD and the Commissioner of the Metropolis, which was one of those hard cases make interesting law cases because it arose out of the serial rapist war boys, the taxi cab rapist, who went undetected for a surprisingly long time. The effect of all of the expansion of Article 3 is this, that a victim of crime now has, as a result of the Supreme Court's decision in DSD, a right of action under the Human Rights Act against the police for breach of this secondary duty to investigate serious violence, and it will succeed if the police fell below reasonable standards in the investigation. Sounds perfectly straightforward, but it is, of course, entirely contrary to the English common law of tort as it stood until DSD, because until then, the common law of tort was that the police, whilst they had public duties, whilst they were required to have proper systems and proper supervision, and of course to operate in good faith, they did not owe a duty of care to individual victims. That's Hill and the Chief Constable of West Yorkshire, House of Lords decision, repeatedly reaffirmed, endorsed by the House of Lords in Van Cole and Smith, and after heavy challenge in those cases, and again by the Supreme Court in Michael and the Chief Constable of South Wales. Now, as it happens, the claimant victims in DSD would have succeeded also under the common law. But the real importance of DSD lies in the consequences from the majority of cases where the result would be different. And claimants can now succeed under the Human Rights Act where previously they would have failed at common law. That's a radical change. And it arises because the Supreme Court simply accepted that the result of the developments in Strasbourg was that the duty to investigate went that far. And Strasbourg got there by a series of progressive glosses, and the steps were largely unacknowledged as they were taken. But never mind, they were taken and repeated. Article 3, remember, prohibits state misbehaviour. It says the state isn't to subject me to torture or cruel and inhuman treatment. If I am set on by an organised gang, or for that matter by my next door neighbour who's taken a dislike to me, that is not a breach of Article 3. The glosses proceeded as follows. First of all, you had a gloss like the gloss on Article 2. There needs to be an investigation of alleged state misbehaviour, because otherwise the right would be ineffective. So that was a case called Asanov. That was entirely comprehensible on the same basis. The second gloss was to construct in the police a duty when they know of an imminent threat to an identified individual, to warn him of it and take steps to protect him from it. That's known after the case in question as the Osman duty. And again, you'll have come across it. Still, we're nowhere near, you may think, a general duty in the police of care to the victims to investigate past misconduct, not to protect against future attack, but to investigate past violence. But without actually acknowledging it, that's what happened. And the Strasbourg Court repeated it frequently. The reasoning for that last step would not, I suspect, have commended itself to any English lawyer. It cited authority which did not justify the conclusion, and in most cases never addressed the point, and it was arguably contrary to the reasoning in Osman. But, never mind, it was repeated time without number in a series of cases, and in due course, when when DSD got to the Supreme Court accepted it on the grounds that there ought not to be so large a difference between the Strasbourg interpretation and ours. And so the result is, as I say, that the absence of the common law legal duty of care on the police towards a victim of crime is now largely irrelevant, because there's a perfectly good right under the Human Rights Act. And a good thing too, many would say, although others might worry about the consequences for defensive policing, the diversion of police resources into defending claims, and the re-litigation of investigations. Those were the considerations which had won the day in Hill, Van Cole and Michael, and we no longer need to worry about those. So there's another example. I don't want to argue the question of which of those is the right reaction. What's interesting is that the Supreme Court simply felt obliged to march in line with Strasbourg. And then let's think briefly, and I've got time just about an aspect of sentencing which throws up a similar question. And I'm speaking, of course, of the vexed and entirely depressing history of imprisonment for public protection in England. The problem, as you'll remember, was that IPP under the 2003 Act was an indefinite sentence. Just as happens with a life sentence, the chap remains in prison after his tariff period until he can demonstrate to the parole board that he's safe to be released. The reasoning of the statute was that you shouldn't have very dangerous people who are likely to cause the public death or serious harm, and that's the test. You shouldn't have them let out until the parole board's satisfied that they're safe. Well, the difficulty was, as you will remember, that there were so many IPP prisoners because of the terms of the statute, that the rehabilitative systems of the prison service couldn't cope. Prisoners ended up in a sort of catch-22 of being unable to demonstrate whether they were safe or not. No one defended what had happened. Specifically, the House of Lords held in a case called James and the Secretary of State for Justice that there was a public law duty on a state which, on our system, on the government, having legislated for indefinite imprisonment, to provide at least reasonable means for prisoners to address the question of whether they were safe or not. That was a breach of public law duty. There was, coupled with that, an ancillary argument that it was a breach of Article 5.1a. Well, what does Article 5.1a say? Everyone has the right to liberty, etc., etc., etc. No one shall be deprived of his liberty, save in, you'll remember the series of cases A to F, is it? E. A, save lawful detention of a person after conviction by a competent court. Well, the House of Lords asked itself the question whether the IPP fiasco, because that's what it was, whether the IPP fiasco constituted a breach of 5.1a, and came to the conclusion that it clearly didn't, because the IPP prisoner was, after all, precisely within 5.1a. He was detained according to law after conviction by a competent court. The fact it was a bad law, wasn't working well, didn't mean that there was a breach of Article 5.1a. In due course, a chamber of the Strasbourg court took a different view in the same case, James against the UK. And they managed to hold that there was a breach of 5.1a. The route involved, the route employed, was to say lawful detention must not be arbitrary. Sounds all right, although the word arbitrary is a Strasbourg invention. It isn't in the convention anywhere. But lawful detention must not be arbitrary. And then two, detention under a system where you have failed to provide the necessary rehabilitative machinery makes the detention arbitrary. Well, in the end, it probably doesn't matter very much whether the claimants succeed under a breach of public law duty, as they did in the House of Lords, or also have a right to complain of a breach of 5.1a, or does it? The Strasbourg court held that there was a breach of Article 5.1a for so long as the particular prisoner in question was not being provided with the necessary courses, rehabilitative treatment, and so on. And to that extent, his detention was arbitrary and unlawful, though when the state got round to providing him with the necessary treatment and transferred him from the local prison where there wasn't any to the long-term prisons where there might be some, and started assessing him as suitable for the courses, then, of course, there wasn't a breach. Those are the terms of the decision in James and the UK. So, should he have been released or not? If his detention was unlawful at point A, he has to be released, hasn't he? And by what possible reasoning can you not release somebody whose detention is unlawful? Now, the Strasbourg Court contented itself in James by saying that it would be, it's their word, regrettable if such a prisoner had to be released, rather than the state got round to producing the necessary courses. And they said it didn't seem to have happened that anybody had to be released. Well, that was true. But there must be some limit to the inventiveness of the construction of these provisions, at least as it seems to me. And in due course, some more IPP cases came back to us in the Supreme Court in a case called Haney, and we did have to address exactly that problem. Interestingly, neither the minister nor the various claimants were prepared to argue before us that the effect of the breach of Article 5, for which the claimants contended, would be that the prisoners had to be released. They all contented themselves with saying, well, all that's required is that you must put your house in order. But that just will not work. So what actually happened, rightly or wrongly, was that the Supreme Court coped with the impasse as best it could. It refused to accept the Strasbourg ruling that there was a breach of 5.1a, because the consequence would have been that all these people had to be released, as it were, from the moment that the illegality was discovered. So, in other words, from the moment that they brought a judicial review claim based on habeas corpus. So we refused to accept that, and instead treated the Strasbourg decision as one of asserting a secondary duty, rather like the Article 3 and Article 2 secondary duties, a secondary duty to provide a reasonable opportunity to the prisoner via courses or whatever to demonstrate that he's safe. And then the Supreme Court said breach of that duty doesn't make the detention unlawful, but it does sound in damages or other remedies. Now, that may or may not be a sensible outcome. It is not what the Strasbourg Court had said in Strasbourg, positively not. It is certainly an example of the Supreme Court analysing a problem of the criminal law and procedure entirely in fundamental rights terms, albeit that it had to reach a conclusion which varied on a really quite important point of principle from that of the Strasbourg Court. But it also might be said to be an example of the Supreme Court adopting the kind of imaginative, and I frankly would say extravagant, method of creative interpretation, which we would never do in a domestic case. But there we are. Now, that, I think, raises quite an interesting question about how our approach to the fundamental rights, which we all take for granted, works out in practice. We ought, I suspect, to be asking whether fundamental rights ought to be susceptible to quite different principles of construction from other areas of the law. Maybe they should, but it's a complicated question. What price certainty? What price knowing where you are? Is it pure Solomon? Does it matter that the rights which are, as drafted, are being so expansively interpreted by judges, not by parliaments, but by unelected judges, without any reference back to the states which originally agreed them? Or, maybe, is that what the states have voluntarily signed up to in accepting both the convention and the jurisdiction of a transnational court such as Strasbourg? The mechanics of referring each point back to individual states for renegotiation of the treaty would be complicated, to say the least. But the question, I think, needs to be thought about. In other words, these fundamental rights and their interpretation are, as it seems to me, a potent example of what is really a perennial problem faced by all legal systems, which is how far should or can judges be creative in their interpretation of the law, or how far are they, like everybody else, bound by what it actually says? It's a perpetual problem, particularly faced by courts of final appeal, but also to some extent by courts lower down. And there isn't time, but I could ask the same question by reference to other aspects of the Convention. Article 6.2, the presumption of innocence, does it apply at all outside the process of determining whether someone should be convicted or not? Does it apply, as the Strasbourg Court has repeatedly said, at least in form, to any expression by any court, criminal or civil, as to whether an acquitted defendant actually did the act? And if so, what of the civil action by the woman who says she's been raped, but whose defendant has been acquitted? What of the care proceedings in the family court in relation to the second child, when it's based on the suggestion, on the allegation that the father shook the first baby and caused its death? The point being, of course, that there's a difference of standard of proof, fundamental difference of standard of proof. That's Article 6.2, you can think about that. And another example is, and you'll find that addressed by the Supreme Court recently in a case called Hallam and Neelan, in the rather specialised context of compensation for miscarriage of justice. But it's not really about the rules for compensation, it's really about the ambit of Article 6.2. And then another one is Article 7, which, as you know, specifically says, first of all, that you can't convict someone of something that wasn't an offence when he did it, and that's always been the English rule anyway. And it adds, nor shall a heavier penalty be imposed beyond the one which was applicable at the time the offence was committed. That's so-called lex gravior. In Scopola, an admittedly hard case from Italy, in Scopola, the Strasbourg Court held that it was implicit, that's its word, in Article 7, that you should add to it, and a defendant shall be entitled to the benefit of any less severe penalty which has been enforced at any time since he committed the offence. Well, you'll see that discussed in a case called Doherty in the Supreme Court. Basically, English sentencing practice has always been that if the law is changed to reduce a sentence, it doesn't happen very often, but it has been known. If the law is changed to reduce a sentence, you pass the sentence according to the principles as at the time you pass the sentence. What you do not do is look back and see whether sometime in the interim between, shall we say, a historic sex offence committed in the 1970s and a conviction in 2019, you do not look back and see whether in 1990, because of particular rules, he'd have been sentenced more leniently either than at the time of the offence or now. And it's a very interesting proposition, you might think, that Article 7 contains this addition implicitly. At the time that Article 7 was drafted, they thought about it, it was tabled, they discussed it, and they decided not to include the additional sentence. So it's implicit in a specifically, specialised sense. If you ask an English lawyer whether something is implicit, he would say, well, does it go without saying? It clearly isn't that. It's a different approach. It's a different technique. And it's one of the things that I started by saying. You've got to be alive when you think about the ambit of all these expansions, about the difference of approach as between the common lawyer and the Code Napoleon lawyer. Almost enough. There are just two other things which I think probably ought to be mentioned. You really can't address a topic like this without at least mentioning the Horncastle experience. The story's far too well known to rehearse. We're on Article 6.3d, aren't we? Everyone charged with a criminal offence has the right to examine or have examined witnesses against him and to obtain attendance of his own witnesses under the same conditions as witnesses against him. So in other words, you can call your own witnesses, but you can also examine those against you. It's hearsay, and what I think is really interesting about the Horncastle experience is not whether it's an example of the English courts standing out against Strasbourg, nor is it really about whether there is a dialogue between them, though actually there was. What I think is interesting about it is this. English law, as we all know, started in the 19th century or before with the proposition that hearsay evidence was inadmissible, full stop, because it's not the best evidence, essentially. But over the years, it then discovered that unless exceptions to that rule were allowed, that would work terrible injustice. Often there are good reasons why you can't call the primary witness. She might be dead, and often the hearsay evidence is demonstrably reliable, such as trade records, or the note that Granny made at the bus stop of the car from which the shots came. So the common law systems started with blanket inadmissibility and then granted on exceptions, chiefly by legislation. It happened here, it happened in the other common law systems as well. By contrast, in the Code Napoleon system of judicially supervised case dossier assembly, the idea of hearsay was completely unknown. Everything was evidence, in the same way as a family lawyer today would say everything is evidence, and you simply assessed its weight. And no doubt, if it was second-hand, you took into account that when you came to assessing weight. So that system started with no inadmissibility at all. So you had everything admissible, no hearsay admissible, and the two systems did that. Because confronted with Article 6.3d, the Code Napoleon systems suddenly said there is a right to confront the witnesses, and that means that all hearsay must be inadmissible. That was partly influenced by the American approach to confrontation. It was thought to derive from Article 6.3d. Personally, as far as I can see, Article 6.3d is almost certainly not intended to have anything at all to do with hearsay. It's about a public trial. But never mind, that's where it was founded. And so the Code Napoleon systems swung dramatically, or particularly in Strasbourg, swung dramatically to total exclusion. As I say, the two systems passed in opposite directions and did that. And the Code Napoleon system ended up with the rule that you'll know about in Al-Khawaja, that hearsay was wholly to be excluded, whatever the circumstances, however reliable, and whatever the reasons why the primary witness couldn't be called, if it was the sole or decisive evidence. And that's the point at which the Supreme Court jibbed in Horncastle, and as you know, when Al-Khawaja went back to the Grand Chamber, they modified it a little and settled for a flexibility. And you might think that that reflects a good deal of good sense on both sides, but it really is a fascinating example of what I was trying to say at the beginning, not illustrating very well, of the synthesis of differing legal cultures. And the other thing that occurred to me when I was thinking about this theme is that although we've seen that a good deal of English criminal procedure and evidence may fall to be reasoned according to fundamental rights, a larger part of English criminal procedure is entirely independent of fundamental rights. It's perfectly right that we should focus now on the necessity to consider their impact, but it ought not to induce in us the idea that those are the prime source of our rules of fairness in the criminal justice system. It's actually the other way around. That's not a jingoistic claim, but most of English criminal procedure was in place before these rights were derived from it very largely. When it was drafted, the convention, very largely by English lawyers for the historical reasons that we happened to be in control at that time, when the ECHR was drafted, only some of the common law principles of criminal justice went into them. Others, which wouldn't have worked in the continental system, were deliberately left out. You'll be able to think of lots of examples of that, and of those which even now have not been added, even by the kind of judicial creativity that I've been talking about. Jury trial, for one. The right to be tried by your peers, entirely foreign to most continental systems, and it's not there, and nobody's attempted to put it in. The discretion not to prosecute is pretty fundamental to the English system, and it was very much in the mind of Lord Shawcross, who was, you'll remember, Attorney General at about the time of the drafting, but it would be quite incompatible with the continental culture, in which, in many systems, it is mandatory for any prima facie case of crime to be prosecuted. And it's in the constitutions of at least some of those countries, if my memory serves me right. It's in the basic law in Germany, and it's in the Italian constitution. It's probably in several others as well. The cab rank rule is, it's not a rule of law, but you try and make the English system work without it. Couldn't conceivably work in the continental systems in which the cadres of advocates are separated rigorously into public prosecutors and others. And more recently, certainly in my limited lifetime in the criminal law, easily the most fundamental change which has happened was the introduction of mandatory recording of police interviews in 1984. Where's that in the Strasbourg jurisprudence? You will not find it. So where do we end up? I think we end up with this, that these fundamental rights are very important. They're often debated. They're sometimes inspirational. They throw up the most fascinating meeting points of the common law and different legal cultures. But they are a long way from the prime source of English criminal law and procedure. They are fundamental to us in the sense that their ideas are embedded in our system. Absolutes, they are not. And you need to be careful about claiming that they're absolutes. The reality is that there is a huge range, a huge scope for debate about their content, and that debate is being resolved, has to be resolved by judges. It's being resolved by exactly the same tensions that you meet domestically between the legitimate bounds of judicial creativity and the rule that judges, like anybody else, are bound by the law. That's a tension which has to be resolved here, as it does everywhere else. They're fundamental rights. they're not absolute rights. There we are.
Thank you so very much, Lord Hughes. That was the most fascinating set of insights, not only into how criminal procedure thinks of international human rights, but also, I think, raising some really fascinating comparative questions and indeed, thinking of Goldsmiths' themes, socio-legal questions about the impact of different legal cultures, different institutional structures in how courts work and how communication between systems works. So it's a really marvellous lecture. Now,